Welcome, everyone. My name is Elizabeth Beth Cannellan Smith, and I'm of counsel at Verrill in the Labor and Employment Group. I have a lot of experience with the Maine Workers' Compensation Act, having practiced in that area for nearly 29 years. I'm currently the main member of the National Workers' Compensation Defense Network, serving as secretary of the board presently, and I'm also the chair-elect of the American Bar Association Tort Trial and Insurance Practice Workers' Compensation and Employers' Liability Committee to assume the chair this August. As many of you know, Verrill's Labor and Employment Group typically hosts a full-day annual seminar for our clients and guests at the beginning of the new year. However, the past year has been one like no other, and like all of you, we've had to pivot to continue to provide the excellent service to our clients for which we are known. We therefore decided to present our annual seminar in a new format, offering a virtual 1 hour to hour and a half session every month on important trends and emerging topics of interest to people tasked with deciphering and applying the ever-evolving world of labor and employment law. My topic today is the ABCs of workers' compensation. It's essentially a primer on the basics. This is the 7th segment in our ongoing virtual annual seminar program. Our next installment will take place in August with a topic to be announced soon. The presentation materials will be posted in a link in the chat box with the SHRM and CLE credit information. We'll have a question and answer portion of the program. So if you have a question at any point during the presentation, please simply use the question and answer button at the bottom of the presentation screen. We look forward to a lively and collaborative session. So with that, Anne, let's start the presentation. So I want to read the mission statement for all of you. This is the mission statement of the Maine Workers' Compensation Board: to serve employees and employers of the state fairly and expeditiously by ensuring compliance with the workers' compensation laws, ensuring the prompt delivery of the benefits legally due, promoting the prevention of disputes, utilizing dispute resolution to reduce litigation, and facilitating labor management cooperation. One of the big changes that occurred in Maine in 1993 was an effort to eliminate disputes in the system. I want to point out that they serve the employees and employers of the state. Our current system right now is much like many of the laws that are enacted to serve employees. It is a bit employee biased. So I just really want to make sure everybody's aware that first and foremost, the emphasis is on the injured employee. Back in the day, a little before I started practice, back in the 70s, actually, I think I was in grade school. Anyway, there was a provision of the act that actually ordered that the act be construed liberally in favor of employees. That's been eliminated. It was eliminated probably in the early 80s, I believe. But nonetheless, the administrative law judges do definitely construe the act liberally in favor of injured workers. And that makes some sense. I'm going to give you a little history on the Workers' Compensation Act, the origin. In Maine, the first workers' compensation law was enacted in 1915, so just at the dawn of the industrial age. Prior to that time, if a worker was injured, they had to sue in court under a tort theory and had to show fault in order to prevail against the employer. And that, as you can imagine, would take a significant amount of time, effort, and frankly, probably more resources than an injured worker might have. What that meant practically was that the community was sourced with supporting this injured worker, because most likely it was the injured worker who was the breadwinner for the family. So if they were injured and unable to earn wages, then the family was not getting money, and that could have really dire consequences. So under the new system, employees would receive statutorily defined compensation for lost wages and medical treatment. And in exchange, they would give up their right to sue under a tort theory such as negligence, loss of consortium, any of those kinds of claims. Those were gone away in exchange for the swift delivery of benefits. Employers gave up their defenses such as assumption of the risk or contributory negligence, but they were guaranteed a limit on the damages that they'd have to pay. This is known as the grand bargain. So if you hear that term, that's what it means. That's everything about workers' compensation. Generally, as noted above, workers' compensation is no fault, meaning it doesn't matter if you do a knuckleheaded move as an employee. If you do something really knuckleheaded, it doesn't matter, with two exceptions. So somebody can violate a safety rule, somebody can do something really foolish that they know they shouldn't do and end up injured, and it doesn't matter under the workers' compensation system. That's something kind of important to understand. The two exceptions are if an employee is injured while intoxicated or due to intoxication. And that has further repercussions now that marijuana is legal, both medically and recreationally, in Maine, Massachusetts, and some of our surrounding states. And then the second exception is if you can prove that there was an intent to injure themselves. Those are rarely invoked, as I imagine you would figure out, because first of all, unless you have a contemporaneous blood, urine, or breathalyzer test or some other test that would show intoxication, it's really hard unless you have a coworker or somebody who can say, oh yeah, he was definitely intoxicated. And also for the intentional injury, it's very difficult to know that somebody intended to hurt themselves. It's rare, but it's important to know that those are two of the exceptions. And let's move ahead. I'm going to tell you a little bit now about the structure of the board and the offices. So we use the term board for two reasons. There's a board of directors. It's made up of an executive director who serves at the pleasure of the governor. Currently, it is John Rohde, who, fun fact, was a housemate of mine when I was in law school. I know him very well. He lives up the street from me because we live in Maine. We all know each other. Then there are there are three labor members and there are three management members. The AFL-CIO appoints the labor members, and generally the Chamber of Commerce appoints the management members. The executive director, as I mentioned, serves at the pleasure of the governor, and so they can be ousted if they're not pleasing the governor, but that really doesn't happen that often. Then we have regional offices. In Maine, there are 5 regional offices, and every contested claim is assigned to a regional office depending on where it's the employee where they live. So as everybody knows, Maine's a pretty big state, and an employee might live in a remote area but work in another area. The case will be assigned to the area where the employee lives. So our regional offices there's one in Caribou, there's one in Bangor, there's one in Augusta, there's one in Lewiston, and there's one in Portland. So that's where our offices are. Then we have our administrative law judges. One sits in Caribou, one sits in Bangor, 2 are in Augusta, 1 sits in Lewiston, and there were 3 in Portland. Right now there are 2 because Judge Sue Jerome retired, but rumor has it that the judge who is sitting in Lewiston is moving down to Portland, and they're appointing a new judge in Lewiston. I'm not sure that's happened yet, but just, word has it. So you guys can be ahead of everything on that. Then we have the staff. So we have the board, meaning the board of directors, and then we also have the board, meaning the general staff of the Maine Workers' Compensation Board. So that includes the administrative law judges, it includes advocates, it includes the support staff, and there's a central office in Augusta where there's a whole host of people, including the monitoring, auditing, and enforcement branch, the technology branch, the insurance branch, all those folks work in there. In each office of the regional offices, we have a claims resolution specialist. That person is in charge of sending out what's known as the 10-day letter when a claim is contested. And I'm sure many of you have seen that letter before. What it basically says is the insurer has manifested contest of this claim, and if you intend to pursue it, you're going to need to contact my office at this telephone number within 10 days of receipt of this letter. Most often that does happen. It doesn't always happen, but that's the first notice that we might be moving into the litigation process. Each office also, except for Caribou, has a mediator. In Caribou, our mediator and our claims resolution specialist is the same person. It's Diane Lennon Danforth, who has tremendous depth of knowledge of workers' compensation law. She has done pretty much everything. She was an adjuster when I first started practice. She was an advocate at one point, and she's been a mediator and claims resolution specialist for probably the last 20 years. Very, very bright and talented woman who knows a lot about workers' compensation. Then we have our worker advocates. What happened in the late 80s is the cost of workers' compensation insurance just skyrocketed, and our employers and our insurers were threatening to, frankly, just leave the state. In response to that, the governor called a blue ribbon commission, and they overhauled the entire Maine Workers' Compensation Act. It's basically modeled on the Michigan law with some changes. Part of that, however, was, as I mentioned, trying to move disputes out of the system. So they were trying to eliminate the involvement of lawyers, which isn't going to happen if it's law that's involved. So in any event, they created this advocate division. They are free legal representatives for injured workers. Many injured workers still retain their own private counsel, but many injured workers also take advantage of the free legal advocate system. All of them are now attorneys. Originally, they were not all attorneys, but they are all now. There's also, as you can imagine, hearing secretaries who, frankly, are a great source of information. There are paralegals for the advocates. There's the entire staff you would imagine that you need to run what's essentially a legal department within this quasi-independent state agency. What I will say, for those who don't know, is the people who work for the Maine Workers' Compensation Board, the staff, are incredible people. They're super friendly. If you have a question, you should always feel free to call them, and they will do their best to answer it for you. It's one of the most lovely things about the state of Maine is it's not just everybody knows everybody. Like I mentioned, my housemate was, John Rohde, who's now the executive director, but people want to help you. They want you to succeed. Anne, would you advance the slide? All right, so who's covered? Pretty much everybody. If you're an employer, you need to have workers' compensation coverage. There are very limited exceptions that include an employer that's small, so small that they only employ their spouse or children, or a corporation where the employer owns 20% or more of the stock. So that almost never comes up. If that comes up, I would suggest that you consult your legal counsel, because you want to make sure if you need coverage, you have coverage, because if you do not have coverage, there are serious repercussions, up to and including criminal remedies if it looks like you did it intentionally. That very rarely happens, and I don't mean to scare people by saying, you could be held to a Class E crime, but I just want to emphasize that it's very important to make sure you're getting the appropriate information, because you don't want to be caught having misclassified employees as independent contractors. Pretty much everybody who works at the direction and control of somebody who owns a company is an employee in Maine. It's very rare for someone to be an independent contractor. There's a very strict test. A number of years back, there was a trade group. They put together a group that included the Maine Revenue Service, Maine Unemployment, and Maine Workers' Compensation, and they would check all of the filings, and if it looked like you had misclassified somebody as an independent contractor, you got the 1-2 ringy-dingy, and you needed to be called on the carpet. You had to explain what had happened. There was potential for a small fine if you could negotiate it down, or a large fine if it was clear that you had done it intentionally. So if you think that you are retaining independent contractors, again, I think you should consult counsel, because it's now very difficult to classify somebody as an independent contractor unless they truly have a standalone business that is not your business, and that they offer their services to multiple people. But that's the very basics that you should be thinking about if you think you have independent contractors. As far as benefits available under the Maine Workers' Compensation Act, generally it is wage replacement if you're missing time and unable to work. That's calculated based on the average of earnings over the 52 weeks prior to the date of injury. You average that out, you divide it by 52, whatever that number is, that's the basis for the wage replacement. It's then 2/3 of the figure that you come up with after you divide the 52 weeks by 52, depending on the date of injury, and also medical coverage. and there's a medical fees schedule that controls the amount that medical practices may bill and for which the employer, self-insured, or the insurer is responsible. Generally, they're fairly generous reimbursements, as I understand from deposing doctors, but that's generally what's available. Benefits last for the duration of the disability, and or there's a statute of limitations, like there often is under any type of law, 6 years from the date of last payment. What that means practically is, if we have a situation where somebody's had a work-related injury, they got benefits for a period of time and then were able to return to work, so benefits stop being paid. If something were to come up again related to that original injury, as long as it's within 6 years from the last date of payment, that might be a viable claim. That's something important to understand. Additionally, in Maine, we have what's known as potential lifetime benefits. They're triggered depending on the date of injury. If it's prior to January 1st, 2013, if there is a rating of permanent impairment above a certain threshold tied to the date of injury, that injured worker has the potential to receive benefits for their lifetime. From January 1st, 2013 forward, it's got to be greater than 18%, which is a fairly large figure as far as permanent impairment. I'm going to take a moment and explain permanent impairment as a concept in Maine. It doesn't mean that you're permanently unable to do everything. What it means is a permanent loss of function based on a medical analysis. So somebody could be able to do a whole lot of things like rake leaves, drive a car, engage in regular life. But if they are assessed to have lost a permanent function due to the injury, they may be rated with permanent impairment. Additionally, there's a second concept of permanent impairment in the state of Maine. If you have, in fact, lost a body part, like physically it's not on your body anymore, then you may be entitled to payment of a period of weeks of benefits for the loss of that body part. That's a little bit different than a lot of other jurisdictions, and that's why I wanted to explain that to you all. Anne, could we advance? All right, so originally in Maine, like in many jurisdictions, when workers' compensation law was enacted, it was an injury by accident. So that by accident piece was a term of art under the law that governed whether something was considered work-related or not. As the law evolved, it's turned into simply an injury or an illness that arises out of and in the course of employment. What that means is it happens at work or tied to work activities and while you're doing what you're supposed to be doing for work. So that's what the arising out of in the course of means: time, place, circumstance. Another key piece of a work-related injury is notice or knowledge by the employer that somebody has suffered a work-related injury. If it's something where it's clear, it's witnessed, oh my goodness, my hand got caught in the machine, that's not really that hard to figure out. When notice or knowledge comes into play most often is in two situations. The first is when in passing, like let's say the employee says, boy, I am so stressed because we've had this mandatory overtime. That might be notice of a work-related stress injury due to the mandatory overtime. So I make that a point because those are the most tricky issues. When somebody in passing says something like, oh, geez, I'm so stressed because of mandatory overtime, or boy, I'm really achy since you moved me to machine 6. That could be notice of a work-related injury. And I would encourage our health, safety, environment or HR people to take a moment, take a pause, and invite that employee to explain a little further. What exactly are you saying to me? I'm trying to hear what you're saying. I'm really concerned about this. What can I do? Are you saying that you think that moving to machine 6, so that work-related change, is causing you an injury? And what is that injury? I understand that that may increase the need to, do some reporting maybe under OSHA and maybe under workers' compensation. But in my mind, it's better to be safe than sorry, because you don't want to, a month and a half later, have the employee come forward and say, you know, I told my supervisor that I was super stressed out, or that the move to machine 7 was causing me to have back pain, and he did nothing about it. That's a bad situation. We don't want that situation. So it's better to inquire at the outset and try to get details and document and find out what's going on. One of the other things I think that's important is this change to injury or illness also captures gradual injuries, such as, say, carpal tunnel, degenerative knee disease, degenerative back diseases. Those are the most tricky in this day and age, candidly, because they are cumulative. And I will tell you honestly, what I've seen during this last year and a half is that there are a number of plaintiff attorneys who are mining older injuries, looking to establish not just the acute injury, but also a gradual injury. And that's very tricky to defend against, because we have an aging population. There is wear and tear, and certainly there's wear and tear at work just as much as there's wear and tear outside of work. It just becomes very difficult sometimes to prove that the wear and tear outside of work really is what the cause of the disability or the need for surgery is. So again, conversations, inquiry, very good at the outset. And could we move forward? So 99% of the time, a claim for injury is uncontested, just like it should be. I mean, the whole idea was, if you hurt yourself at work, your employer/insurer should pay for whatever losses you're incurring. It just makes sense. It's just like any other theory. If you rear end me, you and your insurer need to pay for whatever losses I have. So that's logical. So in the uncontested claim process, there's a number of things that have to happen. First of all, you need to contact your workers' compensation insurance adjuster and or self-insurance adjuster immediately and report that there's been an injury at work. You want to give all the details. It's the name, the date, the social security number. They want to know what body part was hurt. They want to know how it happened. And what they will complete is this FROI. It's the first report of injury. So your insurer, your workers' compensation insurer, will complete that form. And that is a form that is filed electronically with the main workers' compensation board. If there is no time lost from work, it's simply held. When time is lost from work, it's filed and it begins the process of a claim being formally established at the board. The next important point is, internally, you should take an injured worker statement. And part of that is because we want to find out, gee, how did this happen? How can I prevent this from happening to any other worker? Or was this kind of a freak situation and it's not going to happen again? You also want to find out, are there any witnesses? And then you want to go to your witnesses. You want to interview them. You want to get their statements. You want to gather as much information as you can, obviously, because we don't want whatever happened to happen to somebody else. So that's part of the investigation. Further, with an uncontested claim, we want to gather the evidence that shows, oh yes, this did happen, and it did happen at work, and gosh, it was a work-related injury, and we're very sorry that happened. We're going to make sure it doesn't happen again. Now, in Maine, an employer has a right for the first 10 days from notice or knowledge of assertion of a work-related injury to direct the injured worker to what's known as a preferred provider. I do encourage my clients to establish a relationship with a medical practice, preferably an occupational medical practice, so that we can have that 10-day provider relationship. What that means is the 10-day provider has copies of our job descriptions with ergonomic information, so they understand what the jobs are. They're best able to say, oh yes, I can understand from the description I'm getting that this did indeed happen at work and is work related. Or on, contrary, we'll move on to that, this couldn't possibly have happened. And they're very able to say, here are the limitations this injured person needs to follow, but they can return to work if you can accommodate these limitations while they recover. Another very important key is most lost time work-related claims also qualify for coverage under the Family Medical Leave Act. It's extremely important that you examine whether the injured worker's situation fits into, additionally, family and medical leave or main family and medical leave. And if so, you need to provide the appropriate paperwork and invite the employee to take that paperwork to the doctor to be completed so that they may enjoy the benefits that exist under the Family and Medical Leave Act or the Main Family and Medical Leave Act, depending on the size of the employer. What that means is the injured worker's job is held for them. Family and medical leave, if you're 50 or more employees within a 75-mile radius, that means for 12 weeks. Main family and medical leave, it's 10 weeks if you have 15 or more employees. So that's a real benefit to the injured worker. It's also a benefit to the employer, because what it means for the employer is that we're not going to face a claim later in time that you didn't provide me with family and medical leave or main family and medical leave. That could be an expensive claim. And or I'm now going to take my 12 weeks, 6 months later, because I'm still having, or I'm having a recurrence of effects related to this original injury. Additionally, most injured workers under the Maine Workers' Compensation Act or any Workers' Compensation Act probably are qualified under the Americans with Disabilities Act. What that means is we need to engage in accommodation discussions. It's called the interactive process. There's also a process under the Workers' Compensation Act where you're supposed to try to return an injured worker to work. It's actually stronger. It's worded much stronger under the Massachusetts Workers' Compensation Act. You actually are compelled to try to return them to work as soon as you can. It's implicit more under the Maine Workers' Compensation Act. But the benefit to an employer is that the less time an injured worker is out of work, number one, the less cost because you're not paying wage replacement. That means a lower premium because you have less of a loss. But additionally, the longer an employee, there's data that suggests the longer an injured worker is separated from the workplace, the longer they're probably going to remain out of work. It's just not a good thing. When you're home, you're disconnected, you don't have a focus, on work. It's easier to fall into a trap of feeling greater pain, experiencing greater sense of disability. So when you're engaged at work, when you're being reinforced with the idea that you may have some limitations, but we value you and you are not viewed as disabled, injured workers are less likely to fall into a cycle of disability. So in an uncontested claim, ideally, as soon as there's work capacity, hopefully day one, but if not day one, as soon as there is work capacity, we engage in the interactive discussion. We return the injured worker to accommodated work, eventually hoping they return to their regular work capacity in their regular pre-injury job, and everything's great. Finally, as far as document retention, remember I mentioned that there's a 6 years from the date of last payment. So at a minimum, documents should be retained related to the injury in the personnel file at least 6 years from the last date of payment. You may need to check with your insurance adjuster to find out when that is, because there can be a lag time between presentation of a medical bill and payment of the medical bill. But I do think it behooves you to check in when a claim is resolved, find out the date of last payment, and make a note to yourself that all of the documents related to that injury should be retained from up to 6 years from that date. All right, Ann. Contested claim process. I'm going to go through that quickly, or actually I'll take my time, but there is another piece I want to mention before we're done. I'll mention at I'll probably detail it at the end of this presentation, but I encourage my clients in both uncontested and contested claims to consider having a temporary transitional duty program. So let's put a pin in that for a moment, but that's something I really want to talk about in depth. It's very important, and it's important for successful management of injury claims. All right, in Maine, about 1% of claims, honestly, are contested. And it's usually because there's something about the claim that just doesn't make sense to the employer. unfortunately, what I'm seeing more and more as my practice continues is a reluctance to pay copays for pre-existing long-term conditions, and therefore the contested claims that I often see are workers who have a pre-existing condition, don't want to pay that copay, and therefore attempt to bring the pre-existing condition within the confines of a work-related condition, whether it's gradual or acute. When that happens, my health, safety, and environment or my human resources folks generally reach out to their workers' compensation insurer or self-insurer, and they say, the story isn't adding up. I don't think this really happened at work. I'd really like you to explore this claim a little deeper. When that happens, just as it does with all claims, our adjuster will contact the employee and ask to take a recorded statement. The recorded statement basically is the employee's first chance to describe what happened, how it happened, what hurts, whether they had pre-existing conditions, what they do for other activities. That can be very valuable as far as just kind of exploring what could have occurred that might have led to the alleged injury. It's not necessarily admissible in evidence. There are some rules under the Maine Workers' Compensation Act that have to be followed if you wish to introduce that into evidence. So I would encourage my employer clients, my health, safety, and environment, or my HR folks, if they think it's a truly questionable claim, to reach out to legal counsel and coordinate with the insurance adjuster or self-insured adjuster before that statement is taken, so that we can ensure that it might be admissible in evidence if we need it for cross-examination in the future. Then we do everything else that we do with uncontested claims. So a first report of injury is completed. It's filed with the Workers' Compensation Board. Then what's filed to indicate that we're contesting this claim, it's called a notice of controversy. It's a form. You can find all of these forms online if you'd like to. Go to https://www.maine.gov/WCB. That will bring you right to the Maine Workers' Compensation Board site, and I can post that in the comments after we're done with this so that folks can noodle around on that site. There's a lot of information there, but all of the forms are there. So you can look through the forms and familiarize yourself so that you know what the forms are. There are also some training units that can be helpful or useful as well. You scroll down to the bottom of that website and there it says training. So that's another place for you to look. All right, when we have the contested claim in Maine, we have a mandatory alternative dispute resolution / mediation process. Now, this is not mediation that's anything like anybody has ever experienced anywhere else but workers' compensation. Essentially, it's an opportunity for the two parties to meet each other across the table in normal times or across the Zoom over the last year. The employee and generally counsel, because if it's contested, usually they have an advocate or a private attorney. So the employee and counsel will explain what they think happened and why they think it's work related and what they're seeking. So they lay out the benefits for which they think they are entitled. And then the employer / insurer counsel will explain why we don't believe we're responsible to pay for those demanded benefits. I generally, if I have a case where I think we can have a meeting of the minds, I will typically speak to my client, decide what our strategy will be, and then reach out to opposing counsel and discuss it prior to the mediation. So if we're going to resolve it, I know that before I get to mediation. Most often what happens is it's an agree to disagree, but it's one of the boxes that must be checked off in order to move forward with a contested claim. Then next, we have very limited discovery. There are 13 questions that the employee must answer, and there's 7 questions the employer must answer. Generally, in my experience, if there's counsel involved, it's 14 questions for the employee. Generally, if counsel is involved, they answer them as obtusely as possible, and I have to ask 4 or 5 times for clarity. It's supposed to provide sort of a roadmap of what the case will be when you get to hearing, but again, like any litigation, it's of limited benefit. However, in Maine, there is a right to request responses to 3 additional questions. So either party may seek answers to 3 additional questions. Most often I will use that if it's a pretty specific situation, and getting some clarification on specific points will help define our strategy moving forward. I very rarely get the 3 additional questions from plaintiff counsel. I'm not really sure why. In fact, I'm not sure I can remember ever getting a request for 3 additional questions from plaintiff counsel. It's most often used by defense counsel. Generally in Maine, we have what's known as a unitary hearing, which means it's one and done. So you get your hearing date, you get all your witnesses ready, you show up, you present your case. First, the employee presents their case, then you present your case. Then generally in Maine, the administrative law judge will invite both parties to submit a final written argument. The final written argument is basically a written persuasive letter saying, this is why you should rule for me, and here are all the points of evidence that support why my view of the case is correct. Once that's been received, the administrative law judge will make a decision, and they issue what's known as a decree. The decree is the final judgment by the administrative law judge on the case. That's not the end of it, however, in Maine. Anne, would you mind moving us forward? So then we get to the appeal process, because as you know, there's always a second bite at the apple. So a number of years back, we reestablished in Maine the appellate division. It had existed at the beginning of my career. We had the appellate division back in the early 1990s. Basically, it's an intermediary appeal body. It's made up of 3 administrative law judges who did not hear the original case. They meet once a month generally. They'll hear a group of cases, and they'll render their decision based on the facts and the law. The only right of appeal is on an error of law. So what that means practically is the administrative law judge doesn't have to get the facts right. And that can be frustrating, I'm the first to say. They don't have to get the facts right as long as they apply the law correctly to the facts that they set forth in their decree. If there is an error, or you feel there's an error in the application of law, you can appeal to the appellate division. They'll make a decision. If you don't like their decision, you don't think it's correct on the law, you may petition the Maine State Supreme Court, sitting as the law court, for review of the appellate division and the original decision. So it's the appeal of the decision. Practically speaking, Maine's law court doesn't like workers' compensation cases, and there's only 2 justices really who have any experience with workers' compensation law. Judge Jobber, who I'm going to tell you, I know everybody, or I'm related to everybody in the state of Maine. I grew up with Justice Jobber. His son was one of my younger brother's best friends. He was a plaintiff attorney for most of his career. So you can imagine where most of his leanings on workers' compensation cases go. Most of the other remaining justices really don't have a depth of experience. And one of the things that's unique is workers' compensation is a statutory law. So if you don't have a depth of experience with it, it's a little bit harder to discern whether the law has been applied correctly. So generally, the law court does not take a lot of appeals. They don't accept a lot of appeals. And in fact, in 2020, they didn't accept any workers' compensation appeals, which is pretty unusual. Normally, they'll accept, say, 5 to 10 in a normal year. And I don't know whether that was due to COVID or what. I will be candid that the Maine Workers' Compensation Board, like many employers, went home in March of 2020. And for the most part, they're only just now beginning to hold hearings. I've had a couple of mediations, but I've only had 1 hearing in the last year and a half, and that was last fall. So things really slowed down due to COVID. All right, Anne, can we advance? This is a slide that I always think is important, because I think sometimes we can get sort of caught up in the weeds and not really recognize the hidden costs. I know no employer, no client of mine wants to have injured workers. Nobody wants to. It's just not a good idea. It's not good for business. And you don't want to hurt. Employees are a valued asset. This is what I think sometimes our ALJs forget, is that our employees oftentimes have a family. It's the work family to which they belong. So when an injury occurs that causes an employee to go out of work, these are the losses that may or may not be recognized. So for the worker, there's a loss in earning power. There's a lot of psychological stress, particularly if the injured worker was considered the breadwinner for the family, which still very often is true in the state of Maine. We have a primary breadwinner, particularly if it's in a high wage job. As I mentioned, you're at home. If you're not going to work, all you're doing is focusing on going to medical treatment, and you can get into a cycle of pain and suffering and feeling victimized, quite honestly. Why did this happen to me? You go through all the experiences of the 5 episodes of grief where, there's loss, there's anger, there's sort of sadness, and then there's acceptance. There also can be a substance abuse risk. One thing I will say is, in the state of Maine, about 3 or 4 years ago, the legislature recognized the opioid crisis. And in response, they enacted legislation that limits physicians' abilities to prescribe long-term use of opioids. And I think that's been a wonderful thing. I don't know how people feel about medicinal marijuana. Without the THC, it can be a tremendous asset in the absence of an ability to take opioids. In the state of Maine, employers and insurers are not responsible for reimbursement for medical marijuana if it's used for an injured worker. That's not true in other states. So that's something that you'll need to check in with your local council. I know in Connecticut, an employer or insurer can be held responsible for paying for that, but that's not the case in the state of Maine. For our employer, it's pretty obvious what our losses are. First of all, we're down a person, and we may be holding open their job because we're hoping they're able to recover and come back to work. So we have this open space, and or we're having to bring in a replacement worker, and then have to figure out how we're going to reintegrate the injured worker into the workplace when they are able to return to accommodated or regular duty work. Coworkers are stressed. They don't know what's going on. Frankly, all of the information around an injury is confidential, and it's on a need-to-know basis. So really only information should be given to, say, the supervisor if they need to know how to help accommodate limited work capacity and how to ensure that the injured worker is staying within their limitations and not trying to do more than they're allowed to do. So that means that say the guy running the machine next to our injured worker isn't going to know what's going on, isn't going to know why they are taking breaks every 25 minutes when the guy running the machine next door can't take breaks every 25 minutes. So we're managing some of those issues. And additionally, there's loss of efficiency, there's loss of productivity. There's potential for OSHA penalties if, in fact, the injury could have been avoided or should have been avoided or was apparent or should have been apparent to the employer prior to the injury. So there are all these extra costs that are hidden that could be eliminated just by looking to cultivate a culture of safety. And can we move on to the next screen? All right, so now here I'm going to get into some stuff that I think is the most important for takeaways. So if you've been sleeping for the last 15 minutes, wake up, here we go, this is important. All right, here are the most important things you should do. First of all, a root cause investigation when any injury occurs at work is super important. Super important, number one, because it's Exhibit A. When OSHA comes knocking and says, why did this injury happen? It's a reportable. And why did you not eliminate the risk to self or others? You can say, we did. We did a root cause investigation. We made sure this would never happen to anybody else. So hopefully it never happens to anybody else. Additionally, if we have a contested claim, a root cause investigation is very helpful for figuring out whether the injury could have happened in the manner, in the place, in the way that's being alleged. I've had a number of contested situations where my health, safety, and environment or my HR person failed to actually get a concrete statement from the injured worker as to where, when, why, how, and then tried to recreate the injury without the where, when, why, how from the employee. And that's just not going to be successful. It really isn't. We need to know what the injured worker is claiming happened in order to determine or try to recreate, could that have happened? The next most important thing for an employer to do is get witness statements if there are any. So we want to, if possible, if it's not such an injury that the injured worker has to be rushed off to the emergency room, and or if that's the case, we connect with them as soon as practical afterwards. Ask who might have been in the vicinity. Did you see anybody who might have witnessed? Get those names and immediately go out and interview those witnesses and request written statements with date and signature from those witnesses. That can do two things. It could bolster the injured worker's claim of injury, saying, yeah, that definitely happened. I saw it, absolutely. So it saves you time and money of contesting a claim. And or it might result in, oh, absolutely not. I was standing there and I watched him like pretend to fall down, so that didn't happen. So it cuts both ways, but it's really important. And it may feel like an unnecessary step, but it's very important to do. Next, as I mentioned in Maine, for the first 10 days from notice or knowledge, so it's not from the date of injury, but it's notice or knowledge of the injury, an employer has a right to direct the employee to seek medical treatment with the preferred provider. Why that is useful is because, as I mentioned earlier, ideally, our preferred provider has copies of every job description with ergonomic details, perhaps has toured our facility and therefore understands how we do our work and what our safety protocols are, and therefore is best positioned to hopefully return the injured worker to accommodated work absolutely as soon as possible, so that we don't lose that injured worker to lost time, to separation from employment, to potentially a long claim. Furthermore, it's very important for an employer at the outset of a claim to establish with the injured worker that we will work with you, but what our policy is that you seek your medical treatment outside of scheduled work hours. That causes the least disruption in any return to work situation or any ongoing work situation. What that can involve is our health, safety, and environment or HR person offering to sit with the injured worker, call the medical practice and say, hey, could you set all of the medical appointments up for 4:30 because this injured worker works from 6 to 3 or 6 to 4, or simply just being a support and saying, when you give me your list of when your treatment is, we'll set your schedule. That may involve bringing in the supervisor, making sure it's workable, but it's a very important component, I think, of engaging the injured worker in understanding that they're still working and yet they are responsible for seeking appropriate medical care. Contact communication should be regular. Just because somebody has been taken out of work for a period of time, that doesn't mean an employer is not allowed to speak with them or communicate with them or check in and say, hey, how are you doing? Beautiful day. I hope you're feeling okay. How was your OT appointment the other day? So that kind of communication is very important. Additionally, we need to communicate the responsibility of the employee to make sure that they're returning their medical restrictions immediately following any medical appointment, so that we have an ongoing dialogue to see if we can accommodate to get that injured worker back to work as soon as possible, and or in the rare situation, we see early on that it may not be possible to return this injured worker to work, and therefore we need to move to Plan B, and we need to help that injured worker understand what moving to Plan B is going to mean, and that it's not that we don't care for them, that we don't value them, that we dislike them, none of that. It's a practical understanding that you may never be able to lift 50 pounds again. Your pre-injury job required you to lift 50 pounds, and therefore I want to partner with you and figure out how we can help you find something you can do productively and not have to lift 50 pounds. And there may not be that job here with us, but we'll figure out where there might be a job that can engage your talents, engage your experience, and help you be successful in society and working. Setting expectations, as I mentioned, that includes not just telling the injured worker that we expect you to set your medical appointments outside of scheduled work hours, but additionally, we expect you to attend, we expect you to attend your medical appointments so that you can recover. I had mentioned I was going to talk about this transitional duty program. So I encourage my clients to have what's called a temporary transitional duty program. Temporary, which means this isn't a new job. I didn't just take away like the work that you disliked and made a new job for you. So it's temporary, and it's got several components. So the first component is when we get our restrictions back, if there are restrictions, can the injured worker perform their pre-injury job within their restrictions? That's number one question. If the answer is no, we move to number two. Number two, can the injured worker perform their pre-injury job with accommodation, meaning maybe we eliminate some of the tasks and yet they continue to perform their job? If that answer is no, we move to number three, which is there a different open available job that meets the restrictions of the injured worker? If so, great, you're doing that job. If the answer is no, then we move to number four, which is always the last option, which is a period of leave during which we hope, with the guidance of medical provider, that you will recover the ability to perform either an open available job or your own job with or without accommodation. Generally, such a transitional duty program should be about 6 months in duration, with regular meetups with the injured worker involving the medical provider as we see if we're going to advance to a place where we can return to pre-injury employment. Then we move to vocational rehabilitation. If in fact it becomes clear at some point that there are either indefinite or permanent restrictions that will prevent that injured worker from returning to any open available job at the employer, then we might wish to engage vocational rehabilitation, which means we would separate the injured worker from employment, but we would engage a vocational provider to help create a resume, explore preferences for new jobs, and help return that injured worker to work that meets whatever the residual capacity to work is. Sometimes our insurance, workers' compensation insurer might have vocational experts on staff, or they would have resources, or again, defense counsel, if you have counsel, or your employment counsel can guide you to those type of experts. Again, that should be a limited program. And one of the innovative things I did with one of my favorite clients was we had an injured worker who clearly was never going to be able to return to a pre-injury or any other open available position with that employer. What we did was we accommodated that injured worker for a period of time, half day, doing accommodated work that was within the restrictions. The second half of the day, the injured worker worked with a vocational provider. And in that way, not only were we providing hope for a future for this injured worker, but additionally, it was less expensive for the employer, less hit on the premium, and there was the future hope that this injured worker would return to gainful employment within their residual capacity. As I said, that's a bit innovative, but it's something to keep in your toolbox when you're thinking about different ways to manage difficult claims. Another tool that we should have in our toolbox for managing difficult claims is to consider what's known as a team meeting. Team meeting generally involves a longer-term injured worker with limitations that just is not progressing toward either an open available position or the pre-injury position with or without accommodation. So what we do is we sit down and we talk about where are we going with this. That oftentimes will involve a supervisor, the HR manager, perhaps our insurance adjuster, perhaps always the employee, perhaps the employee's counsel and our counsel, and sometimes best situation would be the medical provider, so that we can candidly discuss what are the expectations here. We're 8 months out, we've not seen a lot of progress. Where do we see this going? Medical provider, to the best of your ability, can you tell us if you think we are going to get to a place where we can return this employee to work, or you don't? And then we do joint decision making. That's empowering for the injured worker, it's empowering for the employer, and it's a very transparent process. So I think it's the fairest way to address these situations. Another tool that the employer can use is calling in a medical expert to do ergonomic evaluations to help with accommodation. And fun fact, secret fact, many of our workers' compensation insurers actually do have on staff ergonomic experts. They don't advertise it necessarily, but as a premium payer, I would advise you to just ask what resources are available as part of my premium. Do you have an ergonomic expert who can come out even before an injury occurs to perhaps help me tighten up my job descriptions, help me assess my jobs, help me determine how to avoid injury? And or if we've had an injury, do we have somebody who can help me determine whether we can accommodate, whether this proposed accommodation is appropriate for this injured worker to return to work? We're coming to the end of our time. So Anne, could you advance us? I'm going to invite any questions that anybody might have. And I realize that this has been sort of a quick trot through Workers' Compensation 101. So I'm also available offline if anybody wants to email me or call me with questions. As many of you know, most of this is very fact specific, but I'm always happy to, as I say to my clients, I'd rather give you my blessing than forgive you later. So if you have questions, please feel free to reach out. All right, anybody have any questions for me? All right, it looks like everybody is good. We're at 10:28 a.m. I want to point out one last thing that I want people to be aware of, and this is something unique under Maine workers' compensation law. We have a provision, section 220, I believe it is. If the injured worker's injury is deemed non-work related by a preferred provider, as long as our insurer files a notice of controversy, then the health insurer must pay for any medical treatment. We can't make that injured worker go get medical treatment, but we can strongly encourage and say it's going to be paid for by somebody, and we're just sorting through whether it's going to be health insurance or work-related insurance. And that's something that's really neat and unique to Maine. I have some friends in the American Bar Association who are plaintiff counsel, and they absolutely love that provision because what it means is we don't have somebody who's got an injury not getting medical treatment, waiting for a decision. So on that note, let's keep that in mind. Let's go out there, folks, do what you do, and let's avoid work-related injuries as much as we can. Thank you so much.